Welcome everyone to Business Basics Friday. This is Safi Russell, CEO and founder of SDR Consulting, Inc. And a little background about myself. I've been in the industry about 19 years. I'm a CPA enrolled agent based in New York, but I have a virtual practice. So we do work with clients all over and mostly work with small business owners, helping them from business formation all the way through to tax preparation and all that fun stuff in between. And today we have guest speaker Dwayne Duncan, who is going to cover the topic of trademarks and whether you need one for your business and how important it may be. So I'm going to hand it over to you, Dwayne, and we'll take some Q&A at the end. Thank you.
Perfect. Thank you, Safi. I want to start off by thanking you for having me on your platform. I know we kind of covered that before, but again, just thank you for having me, and thank you for trusting me with your audience, right? So, well, today, what I want to go over are the 3 reasons why you want to trademark your business, right? And I am going to say that the 3 reasons, just to kind of give you a roadmap of where I'm headed, are 1, you want to own your business. 2, you want to reduce competition. And 3, you want the power of ownership, right? And before you guys hang up, turn off the Facebook, what have you, just hang on. We have a special offer at the end that I definitely want to talk to you guys about. But again, we want to go over the 3 reasons. So let's jump in. The first reason is you want to own your business, right? One of the things that I did when I left corporate America was I started my practice, my law practice, and I immediately opened up my business and hit the ground running. Right? So the Duncan Law Firm exists, and now I am out here building wealth. I'm on the road to wealth. And as you all know, as listeners and as patrons of Safi's business, that business ownership really is the fastest way to grow wealth. Now, with that in mind, I want to definitely congratulate everybody who's listening, because obviously if you're listening, you're on the road to wealth, you own a business or you plan to own a business, you're an entrepreneur, you plan to be an entrepreneur. So kudos to you and congrats. One of the reasons why I quickly just made that distinction between a business owner and an entrepreneur is because an entrepreneur, let's define entrepreneur. Entrepreneur is someone who runs and operates a business, right? Someone who formed a business and is now operating it. And a business owner is a little different, right? You formed or organized your business, you're operating your business, but you also own your business. And most of you are saying, well, what do you mean, right? I thought when I registered my business, I own it. But I want to make something very clear here today, that you can't claim that you own a business. You can't call yourself a business owner unless you own the trademark for your logo and your brand assets, right? And what I mean by brand assets are your slogan, your trademark color, your trademark scent, whatever it is that's specific to your business. So again, you can't call yourself a business owner if you don't own these. And I'll explain to you the reason why. And it's really very simple, right? And I'll illustrate this in the story. So I had a couple clients. They were brothers a couple of years ago, and they called me up and they were saying, hey, we got into agreement with a potential investor. And eventually what happened was the investment went through, and the brothers they owned a bakery, so we'll call them the Baker Brothers. The Baker Brothers and this new investor, things just didn't work out. The investment didn't work out. And after a while, the investor called them up. An investor was also a distributor of baked goods, right? So it was a bigger bakery, so to speak. So the investor called him up and said, hey, I want my money back and so forth. And he started with threats. One of the threats that he made was, you know what, if I wanted to own your business right now, I could. So of course I get a call from my clients and saying, hey, what's the story? Is this true? And I told him, yes, what he said is true. And the threat was specifically that I had my attorneys look up to see if you owned the trademark, the name of your business, and this nice logo that you have. And we found out that you don't. And he said, if I was that type of a person, and luckily he wasn't, he said, I would just quietly go and register it. And in about 9 months, send you a letter to stop using it and I would take it and slap it on my baked goods and capitalize off everything you've built. And they were shocked when I told them, yes, absolutely, he could do it, right? Because you don't own your business, because you don't own the name and the assets to go with it, right? You registered a business, but you don't own it. So I hope that story kind of illustrates why you would want to actually trademark your business, right? You want to own the assets that go with it. So the second reason, and in the interest of time, Safi, I'm kind of moving quickly. So the second reason is that you want to reduce competition, right? So first reason, you want to own your business outright. The second one is you want to reduce competition. And what do I mean by that? When you trademark your business, you want to, you have the ability to bar any other competitor who's coming later down the line, who may have a similar name or similar brand assets. You'll be able to bar them from registering their trademark, right? So you'll be able to stop them well in advance of even getting off the ground, right? And we'll talk about timing and when you should search your trademark a little bit later, but you'll be able to stop them well in advance, right? And let's say that they do happen to move forward with their business without registering it or without searching whether or not they actually have the right to own the intellectual property, then you have the power to shut them down. You can send them a cease and desist letter. You can have your attorney send them a cease and desist letter and tell them, guess what? We own the rights to this. We own this name, we own this business, we own this in this particular industry, and you cannot use it, right? So you, with your trademark, again, you have the power to reduce competition. Another quick story for that is, I had a client call me, I think it was last year. He said, hey, Dwayne, I want to own Pull Up. And if it's, those of you who don't know, Pull Up is like a slang term that was very popular, I think last year, maybe the year before. And he said, I have this business idea that, I'm going over with my partners and we want to own the name Pull Up. Can you do what you need to do to let us know whether or not we can move forward? So, we sign the agreements, they pay their invoice and everything. We do the search and it comes back that Pull Up is owned by Joe Budden, right? And I come back to them with this information and they immediately said, all right, never mind, we're going to scrap the idea. And that's what I mean about reducing competition, right? In this case, my client couldn't move forward, but Joe Budden now has reduced competition in the space that he was, pursuing with his trademark. So that's the idea that I want you to keep in mind. So again, one, you own your business, right? You own the name and the assets. Two, you reduce competition. And the third reason is you want the power of ownership, right? And if any of you know me personally or follow me on my social media platforms, you know that I'm always toting the power of ownership, the power of ownership, the power of ownership. And the reason for that is, especially in this trademark space, is that, as I said before, you have the power to shut down competition, right? By owning your brand assets, by owning your trademark, you have the power to shut down the competition even at the gate. The other power that you have is you have the power to leverage these assets for money. And as you guys can tell, I like to kind of put stories with it so you understand the context. Again, that's actually the same client who we were talking about with the Joe Budden situation. We recently, this week, in fact, got a call from a business owner who represents an NFL player, excuse me, an NBA player. I won't give you the name, I won't give you the team, but he represents an NBA player. And he calls me up and he says, hey, would your client be interested in either selling this trademark that he owns, or would he be interested in a joint venture? Now, I'm certain that when my client set out to start this business, he had no idea that anyone would eventually call him. He never thought that that would happen, right? It's a small name, it's a small concept, but someone has built an entire business model around that concept. And now they want the trademark. They want to own the name. They want to own the business. They don't want to have to deal with anyone else in this space. And they want to have the power to tell everyone in this space that they have to stop using it. And they're the sole owners of it. So they called us up and they've, right now we're in negotiations. So we will see where that leads to, but it could be a lucrative joint venture. It could just be a simple buyout where my client makes some money and kind of moves on with his life and moves on to another business idea, right? So again, you have the power to shut down the competition. You have the power to leverage these brand assets for money, or for some type of potential business growth that you may not have been able to do on your own, right? And you also have the power to sell your business. And that's key because we're all building these businesses, but with the right offer, any one of us will sell them, right? Someone comes to you and says, I'll offer you, $6 million for your business, depending on, obviously how much your business is valued. You might say, okay, sure, right? But here's the catch. No one's going to buy your business from you if you don't own the assets. Think about it like this. Toys R Us. Let's say you own Toys R Us. I come to you and I say, hey, I want to buy this toy company that you have. And we go through the process and I find out that you don't own the Toys R Us logo. You don't own Jeffrey the Giraffe. You don't own that famous Toys R Us song. All you own is a warehouse full of toys. When I think about that, all I'm going to say is, wait, I'm just purchasing a warehouse full of toys. I can't actually use this name and this brand because you don't own it, right? I have to go and find the person who actually owns it and pay them for that as well. Or just pay, and the reality of it, if it was me, I would just go find the owner of it, pay them for the trademark and go start my own toy company. I wouldn't have to purchase these toys that Toys R Us has, right? So again, owning the assets is really owning the business itself. And you will have serious trouble selling it if you don't own the actual name, the likeness, and everything else that goes along with this business to make it the business, right? To make it known in the industry. So those are the three reasons. Again, just to recap, you want to own your business, right? You don't want anyone sending you a cease and desist letter telling you to stop, even though you've been building this for 10 years. You want to be the person who has the ability to stop the competition, which is reason number two. You want to reduce your competition. You want to be able to, again, if they even try to register it, it'll come up and they'll be barred by the government itself, something that you don't have to worry about. But for those who are attempting to use it, you can send them a cease and desist letter and do what you need to do to protect your brand. And finally, you want the power of ownership, right? You want to, again, shut down competition. You want to leverage these assets to make some money. And you want to be able to sell your business and not have any issues with it. So overall, those are the three reasons that I came on here today to kind of tell you that you want to trademark your business, right? And I'm not pushing anybody. You don't need to. You don't, whatever the story is, you don't need to. You don't, it's not a must. But these are the reasons why you should, right? You want to protect your business and you want to make sure that you own the business and everything that goes with it. And you want to be able to really use that power, right? So, Safi, I know you said I had a couple minutes. I'm not sure if I'm still on schedule, if you want me to go any further.
Yeah, you're all good, Dwayne. Good information. If you want to, feel free to add a few things regarding like maybe the order in which people should do the trademark. We have.
Right. Okay, good. So let's talk about the order of the trademark. Actually, let's talk about the general trademark process as well. The order of the trademark and how you should do it. My personal opinion, right, is that you want to have your trademark search done prior to registering the business. And the reason for that is you don't want to waste your resources. You go ahead and you register, you call up Safi and SDR and her team, and you say, hey, I want to register Acme Photographs. And they say, okay, I think you should speak to the trademark attorney that we work with, right? And see if the name is actually available for you to own, right? Because you don't want to register a business that you cannot own, as I spoke about before. So my personal opinion and my personal advice is that you want to do it in advance so that you don't waste resources, right? There are people who have done this, who've registered a business, who've created t-shirts, hats, tons of products, and only to find out that, you know, a year into the process, 2 years, 3 years, whatever it is, that they can't own the name. And that someone, either the person is not protecting their intellectual property rights and they just haven't found out yet, or someone has sent them a cease and desist letter. And so you've wasted all these resources, and now you have to do the rebranding of it all. So again, do it in advance, right? Just like the trademark, you know, do in advance. And we'll talk about, and one other point that I want to make later on is talking about litigation, right? Yeah, especially if you've been using the trademark in advance, but we'll get back to that. So the general order of the trademark process, you contact my office, we send you a welcome email, and you go through those administrative processes, and we then search your trademark. We do a comprehensive search. It's the federal database, state database, WIPO, which is the World Intellectual Property Organization, the internet at large, social media at large, and apps, like app stores, to see if anyone has the name in the app store space. And once all of that is returned, what we do is we analyze it and provide you with a report. We get on the phone with you, we walk you through the trademark report, and we actually tell you whether or not there are any risk. We point out any risk, and we allow you to make the assessment of whether or not you want to move forward, right? We do provide you, again, with a written opinion letter and a recommendation that we do or do not think you should move forward. One of the good things I think about searching the name before you even go ahead and get started is that we can allow you to, we can tell you whether or not you may need to just tweak the name, right? In order to avoid any issues down the line, any trouble down the line, we can just tweak the name by adding so-and-so or taking off so-and-so, or and you know, doing X to it. So once the search is completed, we give you our recommendation and our advice. Then the next step would be to trademark it, to actually do the submission. So then we would gather all the documents and evidence necessary. We would submit it to the government on your behalf. And just as a note, the whole trademark process takes about 9 to 12 months. And with COVID, we've been seeing far more delays, right? But in general, it takes about 9 to 12 months. And so for the first 3 to 6 months, we may not hear anything. We'll just be sitting around waiting for the government attorney, because every trademark has a government attorney on the other side, the government attorney to get back to us and say whether or not we've met all the requirements, or whether or not there are any issues, and whether or not we need to make any legal arguments or make any procedural changes of that like. So there's that waiting game. But once the attorney is assigned and things get rolling, that's when you'll see, you know, from our team, emails going back and forth. You will reach out to you and say, hey, we may need this, or what do you think about this? We want to take this approach in handling this. What do you think? Is this something that you're okay with? And then once all of that aspect is done, the trademark then moves to publication. And what happens in publication, which is very important, is that, which is why it's important for you to do a search, is that for 30 days, the trademark is published in a government newspaper or in a publication where anyone can, object to your trademark on the basis that it infringes on their intellectual property rights, right? They own a certain trademark in this space, and your intended trademark may infringe on theirs. So if there are objections there, there's a whole process and back and forth that needs to be resolved, negotiations that may need to happen. And then once it's through that process, then it moves on to registration. And once everything has been finalized, we'll get the certificate, we'll send it over to you, and we'll all have a big party, right? And be happy that you now own this business outright. So that's the general process. The one other thing I just wanted to touch on was, and I should have touched on it earlier, was litigation, right? Suing. and here's the scenario. You've been using your trademark now for 10 years. Excuse me, you've been using this brand name for 10 years, this logo for 10 years. And all of a sudden you get a cease and desist letter. And you call me up and you say, hey, I got a cease and desist letter. We know we never trademarked, right? Because that's gonna be my first question. Well, did you trademark this? No, we never trademarked it. We thought we were fine. Can we sue them, right? We got a cease and desist letter. They have this, they're pretty much using the same logo that we've been using. They're using our same name, and they've opened up a store down the block. Can we sue them? Can we get them to stop? And my answer is gonna be yes, right? We live in America, you can always sue. But the reality of it is this. For most small business owners, they cannot afford to take a trademark infringement matter through the federal court process, right? Again, you're going to federal court, the fees are more, the attorney's fees are 2, 3, 4 times as much, right? And so just the average cost of a cookie cutter slam dunk trademark infringement matter is going to run you about $120,000 to $150,000, right? And it's going to take about 2 years to resolve. If it's, and that's again, it's a plain, simple cookie cutter one. If this matter is bigger and larger, it is going to run you in the high hundreds of thousands, if not into the millions. And a prime example of this, and you guys can look this up, is WWF versus WWE. Well, actually WWF versus WWF, right? WWF was the World Wrestling Federation way back when. And I remember when they changed to WWE, World Wrestling Entertainment. And the reason for that is they were in a very costly, it was over like £1 million, which is about $1.5 million, costly litigation for the initials WWF. Another company registered it and was using it in, we won't talk about international trademarks, but they were using it elsewhere. And that company was World Wildlife Federation. And ultimately, Wildlife Federation, excuse me, won the suit, and WWF, the World Wrestling Federation, had to rebrand and change their name. So not only were they out all of the attorney's costs and fees and court costs, but now they had to spend all this money to rebrand, right? So that's a very large example of a big matter and a big case. But I don't think anyone here wants to go up against anyone with deep pockets. If you're a small business owner, you're not going to win. And I don't think most small business owners have 6 figures to throw at a lawsuit, right? That could have been prevented with, $2,000, $3,000 in the very, very beginning, right? Litigation is very costly. It is extremely costly, and it is very time consuming. And what happens during that time, from the time that you receive the cease and desist letter to the time that the suit is resolved, 2 years, 3 years, whatever the case may be, you're in limbo. You can't actually move forward with anything in your business. You can't use it because you receive a cease and desist letter, and any potential profits that you make during that time could potentially go to the actual trademark owner. So you're in limbo, and again, as a small business owner, I don't think anyone can withstand 2 years of being in limbo and a 6-figure attorney's bill for trademark infringement. So keep that in mind. Yes, you can always sue, but to sue is not a cheap or an easy endeavor, right? So I think that we've hit, the 3 reasons why you should. We've gone over the general process of it, and we've touched on just general litigation relating to it, because I always get that question, like, well, I'll just sue them because, I was using it first. I was using it for 10 years. So just something to put in your back pocket for your thinking, for your trademark. Safi, anything else you want to talk about? Any questions that we may have on the floor?
You know what? That was so good, Dwayne. Thank you so much. Because, for me, trademarks was always like, what's the difference? Trademark, copyright? And I won't start that discussion. I'm sure that's right. Topic, but it was very helpful, everything you said. And I just want to kind of touch on the difference between registering your business versus the trademark. So if you are forming an LLC or a corporation in your state, yes, there's a name check that goes along with that, and you can't use the same name as someone in the state. but that's only for your state. So if I'm setting up an LLC in New York, or a corporation, SDR Consulting Inc., someone in New Jersey could set up that same company.
Absolutely.
Trademark, from what I'm understanding, protects the name as a whole in all states and internationally as well, or?
Well, there's the international trademarks separate, but yes, in all states within the US, right?
Okay.
So yes, Safi, what you said is absolutely true.
Right.
Someone else can have your exact same business name in another state, and that's perfectly legal.
Right.
Now, when it comes to federal trademarks, it's the first to register that has the legal right, right? So you want to make sure that you're that person who was first to register.
Got it. Okay, perfect. Thank you for clarifying that. And so,
No problem.
you know, for people who are just getting started, you know, if you want to own that name, and now that you understand the importance of owning that name, ideally you want to start with that trademark process first. And because it takes so long, it's something you want to get started before you even start the branding and the website. And, you know, I didn't realize it took that long. So thank you for sharing that. So that was, you know, great information. If anyone from, you know, Clubhouse or here in Facebook has a question, we'll stay on another minute or so to take those questions. And then if not, we're going to wrap up, and he's going to tell us about his offer. But I definitely appreciate you taking the time, Dwayne. I definitely want to have you back again. You know, I personally use Dwayne as my lawyer, business lawyer, and refer my clients because he knows the stuff. So if you don't have a business attorney and you're going into business, I highly suggest to come.
Thank you very much. Thank you.
So,
while we wait for questions, I do want to address something that you said.
yes.
The process, right? We talked about it's a very lengthy process, you know, 9 to 12 months, if not longer. But the good news about trademarking is the moment we register, the moment we file, you can begin putting the TM symbol on your brand, right? And so you begin to let people know from the very outset that you are in the process of trademarking this brand and that you have some degree of protection, right? When you get to the end of the process, we'll change the TR to the R in the circle, which means registered. But the TM is what you really want to kind of get out there. So when you think of the overall process, you know, they contact you and they register their business. You let us do the search. You let us begin to get started. You are protected. You have some degree of protection is what I'm getting at. Early on, you don't have to wait the entire 12 months to feel protected. Got
it. So pretty much once the search is done and that part's clear, then you can start doing a TM, using a TM.
Well, once we start the registration. So after the search is done and we move forward with the registration, you can start using the TM.
Got it.
But for your purposes, as far as registering the business, you know, once we tell you the search is clear, right? And your client then says to us, yes, we want to move forward with the trademark, then you're clear to set up and create this business and move forward because the ownership of the rights are in place.
Perfect. Good to know. Thank you. I learned every time. So, all right. Perfect. So that's going to wrap us up for this Basic Business Friday. If you're just joining us, hold on. I spoke too soon. Got a question. Okay. Chris, Brian, how you doing? If you self-fund your business and transfer money into your business account, is that considered commingling funds? So that's an accounting question.
I'll let you handle that. Yeah.
Yeah, it is not considered commingling. So most people do need to fund their business from personal funds in the beginning until the business kicks off. That's just an equity investment into the company in most cases. Depending on your company structure, it may be a loan, you know, depending on your structure. If it's just you by yourself, I wouldn't recommend going through all that because you're going to want to have a loan agreement and have, you know, interest rates and all that established. But outside of it being a loan, it's just an equity investment, and that is not considered commingling. Commingling means that you are running to McDonald's using your business credit or debit card, and it's just a personal meal. You're paying your rent, you're paying, you know, your car note, that's your personal car. You're buying stuff at, you know, Amazon. That's not business related. That would be considered commingling funds. Also, if you're using your personal account directly for business expenses, that's considered commingling. So those you want to avoid, but putting money into your business account is not commingling. So thank you, Chris, for that question. Hope that answered. And he said very informative for you, Dwayne. All right, we have a question on Facebook. So, hey, Ebony, once you trademark the name, the companies in other states can't use it anymore, correct?
Yes, you can send them a cease and desist letter. Right, because now you own the right to that name, and it's a national federal right. And so yes, you can send them a cease and desist letter to stop using it.
Okay. So for example, if someone goes to register in Jersey, same company name, is the state checking the trademarks, or would you have to find out about that some other way?
No, so no, the state is not checking in. So it is your responsibility to monitor it. And we provide monitoring services, and there are other monitoring services that you can actually purchase, right, outside of attorneys, that will check all of this consistently to make sure that no one is infringing on your property rights, your intellectual property rights.
Interesting. Okay. Okay. Thank you for clarifying that. Perfect. All right. Any other questions? Last call. That was good. Okay, cool. If something pops up, I'll let you know. But I'm going to go ahead and close out for anyone who's joined in late and have you go ahead and do your offer. So Safi Russell again here from SDR Consulting, Inc. And this is Business Basics Friday session covering, do you need a trademark for your business? And for SDR, the services we provide is from business formation to tax preparation and all that fun stuff in between, and tax resolution for people who do get into trouble with the IRS or state. And we are a virtual practice, so we work with clients all over. And so Dwayne, go ahead and give your outro, how people can reach you and your special offer.
Sure. So very much like Safi just said, we also have brick and mortar, but we also have a virtual practice. And with trademarks, it's a federal practice of law, which means that we can service clients in any state within the United States. So no matter where you are, you can reach out to us about your trademark. So again, we offer trademark services from search all the way to registration. And we even, for those of you who are DIYers, right, you do it yourself, and you do get into some trouble along the way, right? You get the government attorney who tells you X, Y, and Z, and then you reach out to us. We can pick it up from there and move on as well. I don't suggest that, even though we do it. And and the reason why is because sometimes it'll cost you more money for us to pick up where you left off than if we came in the beginning, because we could have avoided all of the trouble in the middle and avoided all this extra cost and fees. But again, we offer these services. Again, nationally recognized trademark firm. We are located in New Jersey, brick and mortar. But again, we service everyone in every state. If you do need anything from us, the easiest way to get to us really is to book an appointment, right? And with that appointment, you get to speak to me personally for 20 minutes, and we find out what it is that you really need as far as trademarks are concerned. And the way to do that is to reach out to us on our website, and that's LawDLF, L-A-W, DLF, as in Duncan Law Firm, .com/contact. So that's lawdlf.com/contact. And there you'll have an opportunity to fill out a brief questionnaire, maybe like 5 questions or so, and book an appointment, and then we'll get talking. So the special offer that I want to make is exclusive to the SDR family. Safi and I have been strategic partners, and we've worked together for many years now, and we've I think we've been pretty good to one another. And and so as far as extending the offer to our family, our trademarks cost around $2,500, right? And what we're willing to do is offer it to the SDR family for $1,997, right? So that's less than $2,000. If in your comment, and when you complete the form, if you put the SDR family as how you heard of us, Safi's podcast, as how you heard of us, then we will definitely extend that offer and honor it, right? We'd like to offer that through the end of the month, which is really like a week away. So you want to get on it. And like I said, we're here, and we definitely want to help you. One of our biggest goals, one of my personal goals, let's talk about me personally, right? One of my personal goals is to see us succeed, to see people of color succeed. And yes, everybody on this call may not be a person of color, but I just want everybody to succeed, right? So you give us a call, we'll make it happen, right? Well, you need a payment plan, we'll make that happen too. We'll do whatever it is to make sure that you are the owner of your business and that you stand to continue to be on that road to wealth. All right.
Perfect. So I have one more question. Thank you for the
Sure.
offer. Much appreciated.
Absolutely.
Do you have to trademark the company's name and logo?
Do you have to? No, you do not have to, right? Some attorneys will tell you, yes, you have to. You don't have to do anything, right? But the reality of it is, and that's why I started the presentation by telling you why you would want to, right? You do not have to, but do you want to play Russian roulette with this business that you're building? Do you want to receive a cease and desist letter 3 years in after you've invested in all this product, right? And now you have to rebrand. Do you want to have to go to court and spend all this money? Like, no. What you do want is you want to have the power of ownership. You want to be able to stop other people from infringing on this, and for you to kind of be the exclusive person in this industry, right? You want to be able to leverage these assets and make money off of it. And you want to own your business outright. So no, you don't need to, but I think you would want to.
So it's a separate trademarking the name and trademarking the logo, two separate filings.
Yes. Well, I'm sorry, maybe I misunderstood the question. I thought it was.
That was my question that I added on. But
oh, okay. Yes. So the name and the logo are generally separate, right? Unless the name is the logo, and we can get into that issue. But if the logo really is just the lettering of the name, some stylized lettering, I wouldn't push you to get the logo trademarked, right? Because you can't actually trademark a font. And the only thing unique about this particular logo, right, if it's just the lettering of the name, is that you change the font up a little bit, right? So in that case, I would say you only need to trademark the name. But if your logo is unique and it's stylized in any way, then yes, I would say you would want to separate both and trademark both to have protection. Perfect.
Okay, and that was Ebony's question. So I'm glad. So, like in my case, my logo is my company initials. For this part, oh no, they're actually my initials. My name initials are in the company logo. So, sounds like that is two different things. Even though my name is within there,
right?
There's itself.
There's some styling there. It's different. Yeah,
it's different. And just thank you for clarifying that. So I think we're all set. Once again, very helpful. This will be saved and posted in the group for later viewing. So if you're viewing it there or if you're viewing it on YouTube, I'm going to share it with you, Dwayne, as well, if you want to share it. I'm eventually going to get a podcast platform to put all of these on once I finalize those options. But once again, thank you. Very good information. Take advantage of that offer. If you listen to this before the 30th of September 2021, definitely take advantage of that offer. And even if without the offer, I think that's definitely reasonable for the ownership of your business. All right. Everyone have a happy Friday. Have a safe weekend. Dwayne will be in touch. And thanks again.
No problem. Have a good one.
You too. Bye-bye.